What's going on, good people? It is the Bad Wolf. You already know what time it is, and you know I am your man of mysteries and intrigue. And if you have not so yet subscribed to this channel, Badwolf Unincorporated, or my second channel, Badwolf Unrestricted, you better be doing that right now. Go ahead. I'll wait. Okay, awesome. Appreciate you guys. We are going to be delving into the IRS, but this is a treatise on income tax. Now, what is a treatise? A treatise is something where the creator of it knows inside information, or they know the law can be construed wrong, or the statute or the code, and they have a remedy for you to get around it, or out of it, or to exercise your free will. I didn't create this treatise. This was created by Henry Campbell Black, creator of Black's Law Dictionary. So we're going to be continuing. So if you're just now seeing this one, you've already missed the first one. But at the end of the video over here somewhere, you should see a second or a third video pop up, and I'll try to have them all linked. When I'm done with this series, you can find all of them in the courses by going to my main YouTube Badwolf Unincorporated website. Look at the playlist, find courses, and in those courses video, you'll find passport, right to travel, tax treaty, and what's the other one? Right to travel, taxes, passport, and getting started. That particular video will teach you all of the ground rules to this whole world that they've been hiding in front of our peepers the entire time. I highly suggest you watch those. But if not, you just may end up in the back of the class, but you'll still get your education on. So without further ado, let's jump into where we left off and take it from there. All right. So we are going to be beginning with the constitutional validity of income tax, chapter 3, fair use. And this is the treatise of income tax brought to you by Badwolf Unincorporated and written by Henry Campbell Black. Credit to him and his. Now, let's get going.
Ca. Chapter 3 Constitutional Validity of Income Tax Laws 11. Requirement of due process of law. 12. Requirement of equality and uniformity. 13. Equal protection of the laws. 14. Discrimination between corporations, partnerships, and individuals. 15. Discrimination between residents and non-residents. 16. Federal taxation of corporations created by states. 17. Taxation of income from non-taxable property. 18. Taxing salaries of federal and state officers. 19. Exemption of incomes below a fixed sum. 20. Exemption of classes of individuals or corporations. 21. Allowance of deduction for other taxes paid. 22. Double taxation. 23 Taxing aggregate income of family. 24 Validity of graduated or progressive tax. 25 Retrospective operation of statute. 26 Objections as to title, purpose, and mode of enactment of statute. 27 Objections to administrative provisions of Act 28. Apportionment of federal income tax. 11. Requirement of due process of law as applied to the levy, assessment, and collection of taxes. The constitutional requirement of due process of law does not mean that either the validity of the tax or the liability of the particular person or property should be adjudicated by a court of justice. Nor does it mean that personal notice should be given to the taxpayer of each or any step in the proceedings. It is enough if he is informed of the amount for which he is to be charged, and is afforded an opportunity to contest the legality of the tax, the question of his liability to it, or the amount of his assessment, before some board or tribunal empowered to give him all the relief which justice may demand, though it be a board of administrative officers in the first instance, with a final appeal to the courts. Point 1 As this method of procedure has commonly been prescribed by the income tax laws, their constitutional validity has been upheld as against the contention that they deprived the citizen of his property without due process of law. Point 2 In one of the cases dealing with this question, it was said, the claim that the act deprives the plaintiff of his property without due process of law, and denies him the equal protection of the laws, raises questions under the federal Constitution, upon which the decisions of the Supreme Court of the United States are authoritative and controlling. In solving these questions, we must therefore be guided by the decisions of that court. In the Kentucky Railroad tax cases, 115 U.S. 321, 6 sub. Ct. 57, 29 L. ed. 414, the court considered a statute of the state of Kentucky, which involved both these constitutional guarantees. Upon the question of what is due process of law, in the matter of levying and collecting taxes, the court, by Mr. Justice Matthews, said, it has been repeatedly decided by this court that the proceedings to raise the public revenue by levying and collecting taxes are not necessarily judicial, and that due process of law, as applied to that subject, does not imply or require the right to such notice and hearing as are considered to be essential to the validity of the proceedings and judgments of judicial tribunals. Notice by statute is generally the only notice given, and that has been held sufficient. In judging what is due process of law, said Mr. Justice Bradley in Davidson v. New Orleans, 96 U.S. 97, 24 L. ed. 616, respect must be had to the cause and object of the taking, whether under the taxing power, the power of eminent domain, or the power of assessment for local improvements, or none of these, and if found to be suitable or admissible in one black, const. Law, 300, the special case, it will be adjudged to be due process of law, but if found to be arbitrary, oppressive, and unjust, it may be declared to be not due process of law. In its application to proceedings for the levy and collection of taxes, it was said in McMillan v. Anderson, 95 U.S. 37, 42, 24 L. ed. 335. That it is not, and never has been, considered necessary to the validity of a tax that the party charged should have been present, or had an opportunity to be present, in some tribunal, when he was assessed. This language, it is true, was used in the decision of a case in reference to a license tax, where all the circumstances of its assessment were declared by statute, and nothing was intrusted to the discretion of public officers, but in the state railroad tax cases, 92 U.S. 575, 610, 23 L. ed. 663, where the ascertainment of the taxable value of railroads was the duty of a board, as in the present case, whose assessment was challenged for the reason that the proceedings were not due process of law, and for want of notice and a hearing, it was said by Mr. Justice Miller, delivering the opinion of the court, this board has its time of sitting fixed by law. Its sessions are not secret. No obstruction exists to the appearance of any one before it to assert a right or redress a wrong, and, in the business of assessing taxes, this is all that can be reasonably asked. 812. Requirement of equality and uniformity property, as the term is used in reference to taxation, means the corpus of an estate or investment, as distinguished from the annual gain or revenue from it. Hence a man's income is not property within the meaning of a constitutional requirement that taxes shall be laid equally and uniformly upon all property within the state. 4 For this REA 3 Alderman v. Wells, 85s. N. Son, no valid objection to an income tax on constitutional grounds can be based on the fact that it may exempt certain classes of persons or corporations while taxing others, or that it may be graduated or progressive, bearing with increasing severity upon the citizen in proportion as his income increases. Whatever force such objections might possess as applied to a general property tax, a tax on incomes is not included in the constitutional requirement. 5 And where the provision of the Constitution is broader, as, that taxation shall be equal and uniform, still it is said, in relation to income taxes, that this requirement is satisfied by such regulations as will secure an equal rate and just valuation, without reference to the method of valuation, and in order to be uniform a tax need not be imposed and assessed upon all property by the same agency or officers. 6 So, as regards the provision of the federal Constitution that taxes imposed by act of Congress shall be uniform throughout the United States, it is said that the uniformity here required is a geographical uniformity, which does not require the equal application of the tax to all persons or corporations who may come within its operation, and hence taxing a business when carried on by a corporation, and emptying a similar business when carried on by a partnership or by a private individual, as was done by the Corporation Excise Tax Law of 1909, does not invalidate the tax. 713. Equal protection of the laws. Income tax laws have commonly contained provisions classifying the subjects of taxation, discriminating between individuals and corporations, or between residents and non-be Alderman v. Wells, 85s. C. Common residents, exempting certain classes of companies or those engaged in certain pursuits, allowing deduction of some items and not of others, and altogether releasing from taxation incomes below a certain minimum and imposing a gradually increasing burden upon incomes above that sum. On account of these features they have always been urgently assailed as denying the equal protection of the laws, but without avail. This provision, it is held, does not prevent such reasonable classifications and distinctions as those mentioned. Thus, in a decision sustaining the income tax law of the Territory of Hawaii, it was said that the clause in the 14th Amendment to which reference is made does not require taxes to be levied by a uniform method and at the same rate upon every class of property, but the manner of taxation with respect to each class is left to the legislative discretion. 8 Again, the provision in the 14th Amendment that no state shall deny to any person within its jurisdiction the equal protection of the laws was not intended to prevent a state from adjusting its system of taxation in all proper and reasonable ways. It may, if it chooses, exempt certain classes of property from any taxation at all, such as churches, libraries, and the property of charitable institutions. It may impose different specific taxes upon different trades and professions, and may vary the rates of excise upon various products. It may tax real estate and personal property in a different manner. It may tax visible property only and not tax securities for payment of money. It may allow deductions for indebtedness or not allow them. All such regulations and those of like character, so long as they proceed within reasonable limits and general usage, are within the discretion of the state legislature, or the people of the state in framing their constitution. But clear and hostile discriminations against particular persons and classes, especially such as are of an unusual character, unknown to S. Peacock v. Pratt, 121 Fed. The practice of our government might be obnoxious to the constitutional prohibition. It would, however, be impracticable and unwise to attempt to lay down any general rule or definition on the subject that would include all cases. They must be decided as they arise. We think that we are safe in saying that the 14th Amendment was not intended to compel the states to adopt an iron rule of equal taxation. If that were its proper construction, it would not only supersede all those constitutional provisions and laws of some of the states whose object is to secure equality of taxation, and which are usually accompanied with qualifications deemed material, but it would render nugatory those discriminations which the best interests of society require, which are necessary for the encouragement of needed and useful industries, and the discouragement of intemperance and vice, and which every state, in one form or another, deems it expedient to adopt. 9. And again, there is no general supervision on the part of the nation over state taxation, and in respect to the latter the state has, speaking generally, the freedom of a sovereign both as to the objects and methods. It was well said in the opinion of the Circuit Court in this case that there can at this time be no question, after the frequent and uniform expressions of the Federal Supreme Court, that it was not designed by the 14th Amendment to the Constitution to prevent a state from changing its system of taxation in all proper and reasonable ways, nor to compel the states to adopt an ironclad rule of equality, to prevent the classification of property for purposes of taxation, or the imposition of different rates upon different classes. It is enough that there is no discrimination in favor of one as against another of the same class, and the method for the assessment and collection of the tax is not Bell's Gap R. Arco v. Pennsylvania, 134 U.S. 232, 10 Sup. CT 533, 33 L. ed. 892. Inconsistent with natural justice. 10. Particularly with reference to the progressive or graduated features of a tax law, though the statute in question was an inheritance tax law and not an income tax law, the Supreme Court of the United States, sustaining the validity of the law, said, "What satisfies this equality has not been, and probably never can be, precisely defined. Generally it has been said that it only requires the same means and methods to be applied impartially to all the constituents of each class, so that the law shall operate equally and uniformly upon all persons in similar circumstances." X1 and the court in South Carolina remarks, "The right of the legislature of the state to make reasonable classifications of persons and property for public purposes has been so often affirmed by the courts that it can no longer be questioned. If the classification is not arbitrary, that is, if it bears reasonable relation to the purposes to be effected, and if the constituents of each class are all treated alike, under similar circumstances and conditions, the rule of equality is satisfied." 12. South. The Supreme Court of Wisconsin declares, "The sum and substance of it is that the 14th Amendment never was intended to lay upon the states an unbending rule of equal taxation. The states may make exemptions, levy different rates upon different classes, tax such property as they choose, and make such deductions as they choose, and so long as they obey their own constitutions and proceed within reasonable limits and general usage, there is no power to say them nay." 50 L. The same principles apply to the validity of any income tax law enacted by Congress. Although the provision against laws denying the equal protection of the law applies only to the legislation of the states, it is probable that other clauses of the Constitution could be found which would stand in the way of any act of Congress containing arbitrary, invidious, or unreasonable discriminations against individuals or classes. But within reasonable limits, we must not forget that the right to select the measure and objects of taxation devolves upon the Congress, and not upon the courts, and such selections are valid unless constitutional limitations are overstepped. It is no part of the function of a court to inquire into the reasonableness of the excise, either as respects the amount or the property upon which it is imposed. 1414. Discrimination between corporations, partnerships, and individuals. The substantial difference between the rights, privileges, duties, and business methods of corporations and those of individuals engaged in business has been thought to afford a reasonable basis for placing them in different classes, for the purposes of taxation. Hence an income tax law cannot be adjudged invalid, as making unjust or illegal discriminations, because it imposes a different rate of taxation upon the income of corporations from that imposed on the income of individuals, or because it exempts the income of the individual below a certain sum, but does not grant a similar exemption to corporations. Point 15. As to the latter point, in particular, the theory is that an exemption of a minimum income is granted to the individual in lieu of a deduction for personal and Flint v. Stone Tracy Co., 220 U.S. 107, 31 sup. CT 342, 55 L. ed. 389 is State v. Freer, 148 WIS. 456, 134 N. W 673, 26 AM. And ENGN. Ca. 1147, Flint v. Stone Tracy Co., 220 U.S. 107, family expenses, and that no rule of justice requires a similar allowance to corporations, which have no such expenses, a deduction of other necessary expenses being granted in both cases. Point 16. For similar reasons, there is a sufficient ground for classification between individuals and partnerships in the imposition of an income tax. And the Wisconsin statute was sustained by the Supreme Court of that state, against the contention that it made an unjust discrimination in allowing exemptions to individuals which were denied to partnerships. It was said, a partnership ordinarily has certain distinct and well-known advantages in the transaction of business over the individual, arising from the fact that it allows a combination of capital, brains, and industry, and thus makes it possible to accomplish many things which an individual in the same business cannot accomplish. Further than this, however, there is another consideration. If the partner have individual income from other sources than the partnership business, as many do, his exemptions will be allowed to him out of the individual income, and thus, if he were also allowed exemptions from the partnership income, he would be allowed double exemptions. Altogether there seems to be ample reason for the classification. 1715. Discrimination between residents and non-residents. Very serious objections have been urged against the various income tax laws, on account of the discriminations which they have ordinarily made as between residents and non-residents or citizens and aliens. It has been adjudged that the legislature may put foreign insurance companies in a class by themselves, and tax them at the rate of 1% on their gross incomes, while other persons and corporations are taxed. Is Robertson v. Pratt, 13 Hawaii, 590. IT State v. Freer, 148 WIS. 456, 134 N. W 673, 26 AM. And N. 2% on their net incomes and 1% on their property. 18. But has a state any lawful power to tax the income, or any part of the income, of a non-resident, or the United States to tax the income of a person residing abroad, whether a citizen or an alien? If so, is it an unlawful discrimination to grant exemptions to residents and deny them to non-residents? Or to tax the entire income of the resident citizen, and to tax only so much of the income of the non-resident as is derived from sources within the state? And in the latter case, how is the validity of the law affected by the fact that part of the non-residents' taxed income may be derived from business or operations in the nature of interstate commerce? Further, is it essential to the validity of the statute that its administrative features, in regard to the assessment and collection of the tax, should be the same in the case of residents and non-residents? It cannot be said that these questions have, as yet, been authoritatively settled by the courts. They were strongly urged upon the Supreme Court of Wisconsin in the case which tested and sustained the constitutionality of the income tax law of that state. But as they were not necessarily implicated in the case, and as the court held that, even conceding the invalidity of the particular features of the law which were objected to, that would not be sufficient ground for pronouncing it unconstitutional as a whole, no positive decision was rendered. 19 But the opinion of the court contains so full a statement of the questions referred to, and of the considerations which might affect their decision, as to require quotation at some length. Among other things, it was said, it is argued that the provisions which deny to non-residents the exemptions which are allowed to residents, and which allow the Board of Review to increase the assessment of a non-resident without is Robertson v. Pratt, 13 Hawaii, 590. I State v. Freyer, 148 WIS. 456, 134 N. W 673, 26 AM. And N. N. Notice, while requiring notice to be given to a resident, violates Section 2 of Article 4 of the Federal Constitution, which provides that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. The question of the validity of the provision allowing exemptions to residents of the state and denying them to non-residents is raised, and receives some attention in the briefs, but was not mentioned in the oral arguments. We regard it as a question involved in considerable doubt, and one not necessary to be passed upon now. It cannot be imagined for a moment that the legislature would have failed to pass the act had it not contained this provision, and we prefer to wait until the question is presented in a concrete case, at which time there will be opportunity to fully consider it after comprehensive briefs and arguments. It seems that the Supreme Court of the United States decided, in Ward v. Maryland, 12 Wall. 418, 20 L. ed. 449, that one of the privileges and immunities protected by the section quoted is the right to be exempt from any higher taxes or excises than are imposed by the state upon its own citizens. Other decisions relied upon the same side are in Re Stanford's Estate, 126 Cal. 112, 54 Poc. 259, 45 L. RA. 788, and Sprague v. Fletcher, 69 VT. 69, 37 ATL. 239, 37 L. RA. 840, and the cases cited in the latter case. On the other side, reliance is placed on the analogy of the laws providing for exemptions from execution seizure, which confine their benefits to residents, and upon Travelers Insurance Co. v. Connecticut, 185 U.S. 364, 22 Sup. Ct. 673. 46 L. ed. 949 again, in the same opinion, referring to certain sections of the income tax law, it was said, the first of these sections provides, in substance, that a resident shall be taxed upon all of his income arising from rentals, stocks, bonds, securities, or evidences of debt, whether the same be derived from sources within or without the state, but that the non-resident shall only be taxed upon income derived from sources within the state or within its jurisdiction, but that any person doing business both within and without the state shall, as respects that part of his income not derived from rentals, stock, bonds, and securities, be taxed only on that proportion thereof which is derived from business transacted and property located within the state, to be determined in the manner specified in subdivision.
Did you guys hear that? A resident shall be taxed upon all of his income arising from rental, stocks, bonds, securities. Why? These things are considered commercial or products of the U.S. corporation on the public side. Even the word income is their word. Income means money's made from a commercial rental, money's made from stocks, money's made from bonds, money's made from securities or evidences of debt. That is the definition of income. Also, they're saying for a resident, a resident, a res identitied person. Whether derived from the sources within or without the state. Wherever you go, these things can generally be considered to be within their jurisdiction. No matter where that transaction is, but that the non-resident, which is your national side, shall only be taxed upon income derived from sources within the state or within its jurisdiction. Now, what it really should say, sources derived from the state or really through the state. But that any person doing such both within and without the state shall, as respects that part of his income not derived from rental, stocks, bonds, securities, be taxed only on a portion that is derived from business transacted in property located within the state. So if the property is making income as a rental, they should only be taxed on that. There, this is your treatise right here. Let's keep going.
E of Section 1770b, of the statutes, as far as applicable. The general purpose of the section is quite evident, namely, to tax a resident upon his whole income, and a non-resident only upon his income plainly derived from sources within the territorial jurisdiction of the state, and to provide that, where either person is engaged in a business interstate in its character, he shall only be taxed on that portion of the income derived from business transacted and property located within the state, according to the rule prescribed in Section 1770b for determining that proportion of capital stock of a foreign corporation doing business in this state, which must be reported to the Secretary of State. The rule so imported into the statute is an arbitrary rule, and need not be stated at length in the view we now take of our duty with regard to this contention. 2 fundamental objections are made to this section. First, that the state cannot tax the incomes of non-residents, no matter from what source derived, and second, that the attempt to tax a part of the profits derived from an interstate business, under the rule adopted, must necessarily result in a taxation of the receipts of interstate commerce, and hence a regulation thereof, which is in violation of that clause of the federal Constitution which gives to Congress the power to regulate commerce between the states. We shall decide neither of these questions now. If the section be open to either or both of these objections, or any others, we cannot regard that fact as fatal to the act. The legislature evidently intended to avoid both of the objections made. They had a difficult and delicate subject to deal with. Had they been authoritatively informed that they could not constitutionally tax a non-resident's income at all, and could not divide the income derived partially from state and partially from interstate business, we have no idea that they would on that account have abandoned their purpose to pass the law. Again, if they provided an improper rule for the division, conceding that a division can be made at all, there seems no reason why the rule may not be rejected and the proper rule, which will carry out the fundamental purpose of the provision, be used. In any event, we are fully satisfied that the rejection of any or all of the provisions objected to in this section cannot reasonably be held to invalidate the whole act. And again, it was remarked, a strong argument is made attacking the validity of Section 1087, M. 22, which provides in substance that the income of a resident derived from differ and political subdivisions of the state shall be combined for the purpose of determining the exemptions and the rate, while the income of a non-resident is to be separately assessed and taxed in each of the municipalities from which it is derived. A table is submitted showing that under this rule if a resident derived $1,000 from each of 13 different towns or cities, he will be required to pay a tax of $367, because his income is aggregated, and consequently becomes in large part subject to the higher rates, while if b. a non-resident, receives the same income from the same sources, he will only pay the smallest rate, i.e., 1% of each $1,000, amounting to only $130. This, it is said, is unjust discrimination against the residents of the state, and deprives them of the privileges and immunities which are granted to the citizens of other states, in violation of the federal Constitution. This presents the question whether such a discrimination can be made between residents and non-residents, only this time the discrimination seems to be against the resident and in favor of the non-resident. This question, also, we deem one not necessary to be decided now, and we intimate no opinion upon it. It does not seem that the case will frequently arise, but if it does, it can be L.Inc. Tax 333. Be then treated. We do not regard it as in any respect important in considering the validity of the Act as a whole. 16. Federal taxation of corporations created by states. When the constitutionality of the Federal Corporation Tax Law of 1909 was attacked before the Supreme Court of the United States, the objection was very strongly urged that, for the federal government to impose a tax on corporations which received their franchises from the states was beyond its rightful authority, inasmuch as it was imposing a burden upon the right of the several states to create corporations, which might be pushed to such an extreme as to destroy that right, and hence an invasion of their prerogatives, and the crippling of a power rightfully belonging to them as separate governments. The Act of 1909 purported to lay a tax on the privilege of engaging in or carrying on business in a corporate capacity, the amount of the tax to be measured by the net income of the corporation. The Act of 1913 taxes the income of corporations directly and by name. But the same argument, if it had prevailed against the one statute, would be equally potent as against the other. Hence it becomes important to consider the decision of the Supreme Court in which this argument was tested and rejected. Point 20. The court said, it is next contended that the attempted taxation is void because it levies a tax upon the exclusive right of a state to grant corporate franchises, because it taxes franchises which are the creation of the state in its sovereign right and authority. This proposition is rested upon the implied limitation upon the powers of national and state governments to take action which encroaches upon or cripples the exercise of the exclusive power of sovereignty in the other. It has been held in a number of cases that the state cannot tax franchises created by the United States or the 20 Flint v. Stone Tracy Co., 220 U.S. 107, 31 sup. Ct. 342, 55 L. Agencies or corporations which are created for the purpose of carrying out governmental functions of the United States. An examination of these cases will show that in each case where the tax was held invalid, the decision rested upon the proposition that the corporation was created to carry into effect powers conferred upon the federal government in its sovereign capacity, and the attempted taxation was an interference with the effectual exercise of such powers. Point 21 *****. We must therefore enter upon the inquiry as to implied limitations upon the exercise of the federal authority to tax because of the sovereignty of the states over matters within their exclusive jurisdiction, having in view the nature and extent of the power specifically conferred upon Congress by the Constitution of the United States. We must remember, too, that the revenues of the United States must be obtained in the same territory, from the same people, and excise taxes must be collected from the same activities, as are also reached by the states in order to support their local government. While the tax in this case, as we have construed the statute, is imposed upon the exercise of the privilege of doing business in a corporate capacity, as such business is done under the authority of state franchises, it becomes necessary to consider in this connection the right of the federal government to tax the activities of private corporations which arise from the exercise of franchises granted by the state in creating and conferring powers upon such corporations. We think it is the result of the cases heretofore decided in this court that such business activities, though exercised because of state-created franchises, are not beyond the taxing power of the United States. Taxes upon rights exercised under grants of state franchises were 21 citing McCulloch v. Sustained by this court. 22 ******. The cases unite in exempting from federal taxation the means and instrumentalities employed in carrying on the governmental operations of the state. The exercise of such rights as the establishment of a judiciary, the employment of officers to execute and administer the laws, and similar governmental functions, cannot be taxed by the federal government. 23 But this limitation has never been extended to the exclusion of the activities of a merely private business from the federal taxing power, although the power to exercise them is derived from an act of incorporation by one of the states. We therefore reach the conclusion that the mere fact that the business taxed is done in pursuance of authority granted by a state in the creation of private corporations does not exempt it from the exercise of federal authority to levy excise taxes upon such privileges. ******. Nor is the special objection tenable, made in some of the cases, that the corporations act as trustees, guardians, etc., under the authority of the laws or courts of the state. Such trustees are not the agents of the state government in a sense which exempts them from taxation because executing the necessary governmental powers of the state. The trustees receive their compensation from the interests served, and not from the public revenues of the state. 17. Taxation of income from non-taxable property. In passing upon the constitutionality of the United States Income Tax Law of 1894, the Supreme Court held that, insofar as the act levied a tax upon the income of persons or corporations derived from the bonds of municipal corporations, it was 22, citing Michigan Center. Arco v. Collector, 100 U.S. 595, ed. Invalid, because such a tax is a tax on the power of the states and their instrumentalities to borrow money, and consequently repugnant to the Constitution. 24 A similar question arose under the Corporation Excise Tax Law of 1909, but it was held by the same court that the latter statute was not invalid because the income of a corporation subject to the tax might consist in part, or even entirely, of interest on municipal bonds, the ground of the distinction being that the Act of 1909 did not impose a tax on the income so derived, but on the franchise or privilege of doing business in a corporate capacity, the income being merely used as the measure of the amount of the tax in the particular case. 25 The Act of 1913 has reverted to the principle of taxing incomes directly, but it meets the point in question by excluding from taxable income interest upon the obligations of a state or any political subdivision thereof. It had also been held in an earlier case that the Act of Congress of 1864, imposing an income tax, and containing a provision for taxing the interest paid by railroads and some other corporations on their bonded debt, requiring them to pay the tax and deduct the amount thereof from their periodical payments to the holders of the bonds, could not be applied in the case of a municipal corporation owning such bonds, since the municipalities created by the states are entirely beyond the taxing power of the federal government. 26 But whether a state may indirectly affect the borrowing power of another state or its municipalities, by taxing its own citizens upon so much of their income as is derived from the bonded or other debt of such other state or its municipalities, is a different question altogether. But at least it has been decided that there is not. 24 Pollock v. Farmers Loan and Trust Co., 157 U. S 429, 15 sup. CT 673, 39 L. Ed. 759 25 Flint v. Stone Tracy Co., 220 U. S 107, 3 I sup. CT 342, 55 L. Ed. 389 26 United States v. Baltimore and O. Arco, 17 Wall. 322, 21 L. Ed. In the Constitution of the United States to prevent such taxation. 27 It seems clear, however, that a state cannot lawfully tax either its own citizens or non-residents upon their income derived from its own bonds, when such bonds were not taxable at the time of their issuance, for this would impair the obligation of the contract implied in the issue and sale of the bonds, and more especially would this be true where the legislature of the state had covenanted that the bonds should be free from taxation. 28 It must also follow from the principle of the necessary independence of the federal and state governments that the income tax law of any state cannot include interest on the bonds or other public securities of the United States. And state laws of this kind generally make an express exception as to income derived from United States securities, at least where such securities are declared to be tax exempt by act of Congress. But it has been held that the possible impairment of the borrowing power of the government, as the remote effect of a state statute imposing a tax upon the transfer of a decedent's property, when the statute is applied to property consisting of United States bonds, is not sufficient to render the statute unconstitutional. 29 It should also be remarked, in this connection, that a state tax upon the gross receipts or the net income of corporations or individuals cannot validly be made to operate as a restraint upon or interference with interstate commerce, and hence, in the case of carriers and other companies engaged in interstate as well as domestic business, only the receipts from domestic commerce can be taxed by the state. 30 27 Bonaparte v. Tax Court, 104 U. S 592, 26 L. Ed. 845. 2 S Houston and T. Cr. Co. v. Texas, 177 U. S 66, 20 sup. CT. 545, 44 L. Ed. 673, State Tax on Foreign Held Bonds, 15 Wall. 300, 21 L. Ed. 18. Taxing salaries of federal and state officers. The federal income tax law of 1913 exempts the compensation of all officers and employees of a state or any political subdivision thereof, except when such compensation is paid by the United States government. It would not be competent for Congress to lay a tax upon the salary of an officer of a state, and this by necessary implication from the Constitution and the mutual relation of the federal and state governments, neither being authorized to tax the means or agencies employed by the other in carrying out its governmental functions, and hence it was held that a tax assessed, under the federal income tax law of 1864, upon the salary of a state judge was wrongfully imposed, and if paid under protest could be recovered back. 31 And in a similar case it was held to be immaterial that the judge's salary was fixed by the authorities of a county and payable out of the treasury of a city. 32 So, one's compensation as state's attorney is not liable to the federal income tax, nor can such compensation be applied to the satisfaction of the monetary exemption. It must be omitted altogether from the computation of his income, and the taxpayer must have his exemption out of his income from other sources. 33 And for similar reasons, it has been held that a stamp tax imposed by the United States upon a bond required by a state from an officer, as a prerequisite to the exercise of the duties of his office, is, in necessary legal effect, a tax upon the officer's right to qualify, and upon the exercise by the state of its governmental functions, and therefore invalid, and the fact that the tax is required to be paid before the officer has qualified is not material. 34 Conversely, a state income tax cannot be made to apply to the salary of any officer of the United 640, 8 Sup. Ct. 1380, 32 L. ed. 311, State v. United States Fidelity and Guarantee Co., 93 MD. 314, 48 ATL. 918 SI The Collector v. Day, 11 Wall. 113, 20 L. ed. 122-32 Freedman v. Sigel, 10 Blatch. 300 S. States Government. 35 It is considered as settled that the state has no power to tax an officer of the United States, or vice versa, because the power to tax includes the power to destroy, and if a state were allowed to tax a United States officer $1, it might tax him to the full amount of his salary, and thus arrest all the measures of the government. And so the United States cannot tax a state officer for the same reason. 36 The only state income tax law now in force which explicitly recognizes this limitation is that of Wisconsin, which allows a deduction from taxable income of salaries or other compensation received from the United States by officials thereof. 37 But a similar exception must be read by necessary implication into the laws of any other state where the question might arise. Therefore all federal officers, such as postmasters, internal revenue officers, district attorneys, officers of the Land Department, and United States judges resident within the state, must be understood to be exempt from the state income tax, insofar as relates to their salary or compensation from the United States, though, if such officers have an income derived from other sources, it is subject to the tax, as there is nothing in their official character to exempt their private means from state taxation. And it should be observed that the licensing of a merchant under the United States revenue laws does not render him an officer of the federal government, nor withdraw him from the taxing power of the state. 38 And although the salary of an officer in the United States Army cannot be taxed by a state or municipality, yet his personal property, such as household furniture, is not exempt from such taxation. 39 And of course the same principle would apply to his investments or the income derived. 86 Purnell v. Page, 133 N. C 125, 45 S. E 534. 36 King v. Hunter, 65 N. C 603, 613. T. Wisconsin Income Tax Law, 1911, 1087 in, 4, 30, therefrom. And it has been held in Massachusetts that money which one has on deposit in a bank is not exempt from taxation because it was derived from his salary as a federal officer, for it loses its identity as salary when it has been paid to him and come into his possession. 40. As to the incidence of federal taxation upon federal officers, it should be observed that there are some whose salary, while it is to be fixed and appropriated by Congress, is safeguarded from change during their tenure of office by the Constitution itself. As to the President, he is to receive a compensation which shall neither be increased nor diminished during the period for which he shall have been elected. Constant U. Art. 2, 1. And as to the federal judges, they shall receive a compensation which shall not be diminished during their continuance in office. Const. U.S. Art. 3, 1. The income tax laws enacted by Congress during the period of the Civil War contained no such exception. But the justices of the Supreme Court, through Chief Justice Taney, addressed a communication to the Secretary of the Treasury declaring their conviction that their salaries were not legally subject to the tax. Thereupon the Attorney General, to whom the communication had been referred, gave an elaborate opinion, advising the Secretary of the Treasury that the income tax could not lawfully be assessed upon and collected from the salaries of those judicial officers of the United States who were in office at the time of the enactment of the statute imposing the tax. 41 No attempt was made thereafter to assess the tax upon the salaries of the judges. But in the income tax law of 1894, Congress again failed to make an exception in this particular, and the statute was held unconstitutional and void insofar as it attempted to tax the salaries of the judges of the United States Courts. 42 But the Act of 1913 meets this point by Pro 40 Dyer v. City of Melrose, 197 Mass. 99, 83 N. E6. 4113 Op. Attorney. Gen. 161. 42 Pollock v. Farmers Loan and Trust Co., 157 U.S. 429, 15 Sup. CT 673, 39 L. ed. 759, Perfield, J., concurring. Vidying that in computing net income under this section there shall be excluded **** the compensation of the present President of the United States during the term for which he has been elected, and of the judges of the Supreme and Inferior Courts of the United States now in office, the evident intention being that the next President of the United States, and all federal judges appointed after the enactment of the statute, shall be subject to the income tax in respect to their salaries. 43 But as to all the other officers and employees of the United States, including the members of Congress themselves, whose salary or compensation may be fixed and changed in the absolute discretion of Congress, there is no constitutional objection to the incidence of the income tax upon such salaries. Such was the decision made under the Act of 1862 in regard to collecting the income tax from the salary of an officer in the 43. An interesting question might here be raised as to the effect of this provision on the power of Congress hereafter to repeal the income tax law or to change the rate of taxation under it. For if the imposition of the income tax upon the salary of the President would diminish it, within the meaning of the Constitution, and that is the only possible legal reason for accepting the present incumbent, then the repeal of the act would as certainly increase the compensation of any future president to whose salary it had attached at the beginning of his term, which is equally forbidden by the Constitution. And if a president shall be elected while the present statute is in force, any change in the rate of taxation, effected by amendment of the act, would either increase or diminish his compensation, as the case might be. And the same considerations apply to taxing the federal judges, except that their salaries may be increased, but not diminished, during their continuance in office. It would therefore appear to follow, as a perfectly logical conclusion, though an almost absurd result, that if a future Congress should desire to increase the rate of income taxation, it would have to make an explicit exception as to the President and the federal judges, who would then continue to be taxed at a different rate from other citizens, and if it were desired to repeal the act, the President alone must be required to continue paying the tax until the expiration of his term of office. Of course, these complexities could have been avoided by the simple means of absolutely accepting these officers from the operation of the statute. United States Army 44, and the rule is equally applicable to all others save those mentioned in the preceding paragraph. We have next to consider the application of a state income tax law to the salaries of the state officers. Here also the principle applies that if the Constitution of the state protects such salaries from change during the incumbency of the particular officer, it prevents their being taxed as income. Thus in North Carolina, it is provided in the Constitution that the salaries of the most important officers shall not be altered during their term of office, and this is understood to exempt their salaries from taxation, because to tax is to diminish, or it may be to destroy. 45 Hence if the local constitution provides that the salaries of the judges of the state shall not be diminished during their continuance in office, such salaries are exempt from the income tax. 46 It may be that the restriction In this article of the Constitution upon the power of the legislature refers principally to the diminution of the salaries of the judges by a law fixing it at a less amount than that established at the epoch of their entrance into office. The object, however, of this article was to secure the independence of the judiciary. If the legislature can tax the salaries, it would be deprived of its plenary effect. 4t The only decision to the contrary was made in an early case in Pennsylvania, which, however much it may be respected at home, is not entitled to much persuasive effect elsewhere, in view of its opposition to the general current of authority. 48 But unless 44 Galm v. United States, 39 CT 0155. Asterisk 5 King v. Hunter, 46 per. Thus restrained by some explicit provision of the state constitution, it is within the lawful power of the state legislature to make an income tax law apply to the salaries of the various officers of the state and of its municipalities. 49 As is done in Wisconsin in all cases where such taxation would not be repugnant to the Constitution. It should be remembered that public office is not a contract, within the sense of the constitutional prohibition against laws impairing the obligation of contracts. And hence no contract is violated by the imposition of an income tax upon the salary of an officer who was in office and whose compensation was fixed by law, at the time the income tax law came into effect, for his right to the compensation grows out of the rendition of services, and not out of any contract between the government and the officer that the services shall be rendered and the compensation paid. 50 Finally, an income tax law is not to be pronounced unconscionable for their object, and not for their consequence. On any other principle of construction, a tax could not be constitutionally assessed on property purchased with money drawn from a judge's salary, which would, in reason, have as fair a claim to exemption as the salary itself. If we once get away from the plain inartificial import of the prohibition, it is not easy to tell at what stage of refinement we shall stop. The object of the legislature was to apportion the public burden according to the ratio of property, and to produce in detail a result approaching as near as possible to that of an income tax, a measure of assessment more equable in the abstract than any other that could be proposed. Now there is no reason to exempt a judge from contribution which is not just as applicable to any other officer who presents no tangible service but his office to the revenue laws, nor was the object of the prohibition to place him in this respect on higher ground. The legislature could not constitutionally retrench a part of a judge's salary under the pretext of assessing a tax on it, but, for the bona fide purpose of contribution, a reasonable portion of it, like any other part of his property, may be applied to the public exigencies. For in retaxation of salaries of judges, 131 N. C 692. 42 S. E 970. So see Butler v. Pennsylvania, 10 How. Constitutional and void in its entirety simply because it lays a tax upon the salaries of certain officers who are constitutionally exempt from such taxation, or fails to make an explicit exception in their favor. The protection of the Constitution because of such an illegal provision can be invoked only by one against whom it is sought to be enforced, and even in such a case, if the law in affirmative terms lays the tax on such an exempt income, that portion of it can be extended without destroying the rest, while, if it merely omits to make the necessary exception, it can be construed as not applying in the par. Particular case. 5119. Exemption of incomes below a fixed sum. It has been held by a great many authorities that a statute imposing taxes on inheritances, legacies, and successions is not unconstitutional because it exempts from its operation estates or inheritances below a certain minimum value. 52 Provided only that the exemption is not so excessive as to be entirely unreasonable. 53 On the same principle, an income tax law is not unconstitutional because it wholly exempts from guess estate taxation all incomes below a certain annual amount, and the question where the tax shall begin, or where the exemption shall end, is one exclusively for the decision of the legislature. 54 Such a tax law, making a reasonable exemption, is not in violation of a constitutional provision that taxes shall be equal and uniform. 55 And if it is at all within the power of a court to adjudge that the exemption granted is so excessive as to invalidate the statute, at least no such decision has ever yet been rendered. On the contrary, the decisions have sustained the income tax laws in this particular. That of Hawaii, exempting incomes to the amount of $1,000, was sustained as against the objection that the allowance was excessive. 56 That of Wisconsin was similarly held valid, although it exempts life insurance to the amount of $10,000, in favor of one legally dependent on the deceased. The court called this a striking exemption, but said, while this is somewhat large, we cannot say that it is unreasonable. 57. The Income Tax Act of Congress of 1894 was sustained, by an inferior court, as against objection that the exemption allowed, $4,000, was unreasonably great. 58 The Corporation Excise Tax Law of 1909 was assailed on the ground that it exempted incomes of less than $5,000, but the Supreme Court of the United States answered this objection with a mere reference to certain of its earlier decisions concerning similar exemptions in inheritance tax law. 59 Through no decision on this precise point was rendered in the case before the United States Supreme Court involving the validity of the Act of Congress of 1894, yet some of the S** Moore v. Miller, 5 App. D.C. 413, New Orleans v. Forshee, 30 Law, and 910 SB New Orleans v. Forshee, 30 Law, and 910 esse Robertson v. Separate opinions filed in that case contain valuable discussions both of the general question of exempting small incomes and of the limits of the authority of the courts in deciding upon the reasonableness of the exemption. Thus, in one of the opinions it was said, a tax which is wanting in uniformity among members of the same class is or may be invalid. But this does not deprive the legislature of the power to make exemptions, provided such exemptions rest upon some principle, and are not purely arbitrary, or created solely for the purpose of favoring some person or body of persons. Thus, in every civilized country there is an exemption of small incomes, which it would be manifest cruelty to tax, and, the power to make such exemptions once granted, the amount is within the discretion of the legislature, and so long as that power is not wantonly abused, the courts are bound to respect it. In this law there is an exemption of $4,000, which indicates a purpose on the part of Congress that the burden of this tax should fall on the wealthy, or at least upon the well-to-do. If men who have an income or property beyond their pressing needs are not the ones to pay taxes, it is difficult to say who are. In other words, enlightened taxation is imposed upon property and not upon persons. Poll taxes, formerly a considerable source of revenue, are now practically obsolete. The exemption of $4,000 is designed, undoubtedly, to cover the actual living expenses of the large majority of families, and the fact that it is not applied to corporations is explained by the fact that corporations have no corresponding expenses. The expenses of earning their profits are of course deducted in the same manner as the corresponding expenses of a private individual are deductible from the earnings of his business. The moment the profits of a corporation are paid over to the stockholders, the exemption of $4,000 attaches to them in the hands of each stockholder. 60 And in another opinion in EO dissenting opinion of Brown, J., in Pollock v. Farmers Loan and Trust Co., 158 U.S. 601, 15 Sup. OT. 912, 39 L. ed. 1108. The same case it was said, in this connection, and as a ground for annulling the provisions taxing incomes, counsel for the appellant refers to the exemption of incomes that do not exceed $4,000. It is said that such an exemption is too large in amount. That may be conceded. But the court can not for that reason alone declare the exemption to be invalid. Everyone, I take it, will concede that Congress, in taxing incomes, may rightfully allow an exemption to some amount. This was done in the income tax laws of 1861 and in subsequent laws and was never questioned. Such exemptions rest upon grounds of public policy, of which Congress must judge, and of which this court cannot rightfully judge, and that determination cannot be interfered with by the judicial branch of the government, unless the exemption is of such a character and is so unreasonably large as to authorize the court to say that Congress, under the pretense merely of legislating for the general good, has put upon a few persons burdens that, by every principle of justice and under every sound view of taxation, ought to have been placed upon all or upon the great mass of the people. If the exemption had been placed at $1,500, or even $2,000, few, I think, would have contended that Congress, in so doing, had exceeded its powers. In view of the increased cost of living at this day, as compared with other times, the difference between either of those amounts and $4,000 is not so great as to justify the courts in striking down all of the income tax provisions. The basis upon which such exemptions rest is that the general welfare requires that, in taxing incomes, such exemptions should be made as will fairly cover the annual expenses of the average family, and thus prevent the members of such families becoming a charge upon the public. The statute allows corporations, when making returns of their net profits or income, to deduct actual operating or business expenses. Upon like grounds, as I suppose, Congress exempted incomes under $4,000. 61 in any dissenting opinion of Harlan, J., in Pollock v. Farmers Loan and Trust Co., Supra. Other case, in construing a territorial income tax law, the court observed, it is contended that the exemption of incomes to the extent of $1,000 is an illegal discrimination. The power of state legislatures to grant reasonable exemptions from taxation is undisputed. It has been upheld on grounds of enlightened public policy, a public policy which seeks to exclude from taxation the living expenses of the average family, and thus to enable the poor man to escape becoming a public burden. It rests upon the theory that the exemption results in ultimate benefit to the taxpayer, which compensates him for the additional burden of taxation which he is thereby called upon to bear. It does not apply to corporations, for the reason that they have no corresponding expense. But the exemption must be reasonable and impartial, and must be extended to all who are similarly situated. It is urged that the exemption in question is unreasonable. If the power to make exemptions be once conceded, the amount of the exemption is largely within the discretion of the legislature, a discretion which is not subject to review in the courts unless it be clearly shown to have been abused. 6220. Exemption of classes of individuals or corporations. It is a conceded principle of taxation, applicable to income taxes as well as to any others, that there is no constitutional objection to an exemption in favor of those corporations or institutions which serve important public purposes or confer benefits upon the public at large, such as religious, educational, and charitable organizations. Also, it is clear that any corporation which bears its due share of the public burden, under a special form of taxation, may lawfully be exempted from the payment of any or all other taxes. Thus, the exemption of insurance companies from an income tax law does not render it invalid as to other corporations which are made subject to the law, where the exemption is made expressly on 02 Peacock v. Pratt, 121 Fed. 772, 58c. Ca. 48. BL.Inc. Tax 4, 49. The ground that such companies are required by another law to pay a tax on the premiums received. 63. But beyond these elementary principles, the subject is not free from doubt. It would be obviously contrary to sound principles of constitutional law to push the power of exemption so far as to make the burden of the tax in reality fall upon a selected class of individuals or corporations. On this point, the Supreme Court of Louisiana has said, it is not necessary for us to decide whether or not, under the Constitution, the legislature has power to levy an income tax. It suffices to say that, if the legislature has such power, it would be an indispensable condition of its exercise that the tax should embrace the incomes owed to all persons not exempted, and whatever power of classification the legislature might possess as to the subject matter of taxation, that power could under no pretext be stretched so as to embrace the right to single out a particular class of taxpayers and to require them to pay such a tax, while exempting all others. 64. No such sweeping exemptions have been attempted in recent income tax laws. But they commonly contain exemptions in favor of labor organizations, agricultural societies, savings banks, mutual building and loan associations, mutual insurance companies, fraternal orders, and benefit societies, or some of the foregoing, as well as charitable and educational institutions. The validity of such exemptions has been severely criticized. Thus, in one of the opinions filed in the Pollock case, it was said, exemptions from the operation of a tax always create inequalities. Those not exempted must, in the end, bear an additional burden or pay more than their share. A law containing arbitrary exemptions can in no just sense be termed uniform. In my judgment, Congress has rightfully no power, at the expense of others, owning property of the like character, to sustain prize Peacock v. Pratt, 121 Fed. 772, 58 C. Ca. 48. 6 Parker v. VAT trading corporations, such as building and loan associations, savings banks, and mutual life, fire, marine, and accident insurance companies, formed under the laws of the various states, which advance no national purpose or public interest, and exist solely for the pecuniary profit of their members. 65. But in a more recent case the Supreme Court of the United States has apparently given its approval to the validity of just such exemptions as those mentioned. In refusing to hold unconstitutional the corporation tax law of 1909, on the ground that it taxed a business when carried on by a corporation, and exempted a similar business when carried on by a partnership or a private individual, it said, in levying excise taxes the most ample authority has been recognized from the beginning to select some and omit other possible subjects of taxation, to select one calling and omit another, to tax one class of property and to forbear to tax another. And later in the same opinion it was said, as to the objection that certain organizations, labor, agricultural, and horticultural fraternal and benevolent societies, loan and building associations, and those for religious, charitable, or educational purposes, are excepted from the operation of the law, we find nothing in it to invalidate the tax. As we have had frequent occasion to say, the decisions of this court from an early date to the present time have emphasized the right of Congress to select the objects of excise taxation, and within this power to tax some and leave others untaxed must be included the right to make exemptions such as are found in this Act. 6E21. Allowance of deduction for other taxes paid. The Wisconsin income tax law contains a provision that any person who shall have paid a tax upon his personal Prop. S. Pollock v. Farmers Loan and Trust Co., 157 IT. S. 429, 15 Sup. CT 673, 39 L. Ed. 759, Perfield, J., concurring. 66 Flint v. Stone Tracy Co., 220 U. S. 107, 31 Sup. CT 342, 55 L. Erdy during any year shall be permitted to present the receipt therefor to, and have the same accepted by, the tax collector to its full amount in the payment of taxes due upon the income of such person during said year. 67 When the constitutionality of the statute was under consideration by the Supreme Court of the state, an objection against its validity was urged on the ground that this provision created an unjust and unlawful discrimination between taxpayers all equally subject to the law, since one taxpayer might be required to pay the whole of the income tax assessed against him, while another, having an exactly equal income, could have the tax thereon very materially reduced by taking advantage of this provision. But the court held that the objection was without force and overruled it. 6822. Double taxation. Vigorous objections to the validity of income tax laws have been based on the ground that they impose, or at least result in, double taxation. And it cannot be denied that this is usu. Ally the case. It may safely be said that the payment of an income tax almost necessarily involves, in some indirect and limited sense, the payment of a double tax. For income, oftener than otherwise, in some way, either directly or indirectly, is derived from or grows out of property subject to taxation. 69. But though double taxation is vicious and unjust in principle, and no statute will be so construed as to impose double taxes if it can reasonably be avoided. 70. Yet a statute which produces this result cannot be adjudged invalid on economic principles, nor unless it conflicts with some explicit provision of the Constitution. This important point is discussed, in relation to in * Wisconsin Income Tax Law, 1911, 1087 M, 26. 88 State v. Freer, 148 WIS. 456, 134 N. W 673, 26 AM. And Eng. N. Ka. 1147 E Lot v. Hubbard, 44 Allah. 593 to Black, Const Law, 3d ed. Come taxation, by the court in South Carolina, in the following terms. The next objection to the act is that it results in double taxation. The contention is that plaintiff's income was derived from dividends received upon his stock in corporations chartered and doing business under the laws of the state. And as these corporations had paid taxes on their property, and also on their franchises, a tax on plaintiff's income is double taxation. There is much room for discussion and difference of opinion as to what really amounts to double taxation. But the weight of authority and reason sustains the taxation of shares of stock in a corporation to the holder thereof, notwithstanding the corporation has paid taxes on its property and also on its franchises. The rents and profits derived from real estate, and the products of the farm, may be taxed, though the land from which they are derived has also been taxed. The profits of a business may be taxed, though the property in the business, bought on credit, has been taxed to the owner, and the debt he owes therefore has been taxed to the creditor, and the property covered by mortgage may be taxed to the owner, and the mortgage thereon to the mortgagee. These may be instances of double taxation in one sense, yet they are not within the rule of uniformity and equality prescribed by the Constitution, which forbids the taxation twice of the same property for the same purpose, while other property, under similar circumstances and conditions, is taxed only once. There is no constitutional inhibition against such taxation, and in the absence of constitutional restriction, the power of the legislature to tax is limited only by its own discretion and its responsibility to its constituents. It has been said the power to tax is an inherent right of sovereignty, necessary to its existence, and limited only by its necessities. We make out no conclusive case against a tax when we show that it reaches twice the same property for the same purpose. This may have been intended, and, in many cases, at least is admissible. T1 The general weight of authority undoubtedly does sustain the principle that a tax may be levied on income derived from property, in the shape of rent or otherwise, although the property yielding the income is also subjected to taxation, and that this does not violate the rule against double taxation, because the two interests or species of property are distinct and severable. 72 It must be admitted, however, that this doctrine does not pass entirely unchallenged. Point 73. And in at least one state this very result has been guarded against by a clause in the Constitution which provides that the General Assembly may tax trades, professions, franchises, and incomes, provided that no income shall be taxed when the property from which the income is derived is taxed. 7. On the other hand, the Constitution of another state having an income tax law, Wisconsin, expressly makes a distinction between property and income and authorizes the taxation of both. And the Supreme Court of that state, in U.S. Taining the income tax, has remarked, it is claimed with much earnestness and ability that the act violates the provisions of the 14th Amendment to the federal Constitution. One of the contentions under this head is that the progressive features of the act are discriminatory, if not absolutely confiscatory. Another contention is that the act provides for double taxation, and for both reasons it is claimed. 71. Alderman v. Wells, 85 S. C 507, 67 S. E 781, 27 L. R.A. N.S. 864, 21 A.M. and Eng. N. Guess. 193. 72. Comstock v. Grand Rapids, 54 Mich. 641, 20 N. W 623, Woodruff v. Oswego Starch Factory, 177 N. Y 23, 22 N. E 994, Chisholm v. Shields, 21, Ohio Circle. CTR. 231, Memphis v. Ensley, 6 Baxt. Tennessee, 553, 32 AM. Rep. 532-73. We are of the opinion that it was not the intention of the legislature to tax real property under the name of land, slaves, etc., and then to tax under the term of incomes the profits realized from such land, slaves, etc. It would be double taxation, first to tax property to the extent allowed by law, and then to tax the profits derived from such property. City of New Orleans v. Fassman, 14 Law. An 865. And C. Kennard v. Manchester, N. H. 36 ATL.